series, When Words Collide, based on the best selling book by Bill Wilson. And Bill's going to help us this month talking about avoiding claims disputes by preventing the claim dispute on the front end. And this in particular is a session that I'm particularly interested in. So without any further ado, we're going to kick it off to Bill. Go ahead, Bill.
Fantastic. Thanks, Patrick, and welcome everybody. Thank you for coming. I know that there's a mix of folks that are on the webinar today. Most of you are here for the entire series. Some of you are here just for today. I'm hoping I can convince you to sign up for the entire series. If you missed the first three, they're all recorded, so you can catch up. And the best way to do this would be to become a member of the Academy. You get access to the entire 12-part series and dozens and dozens and dozens of other webcasts from some of the best folks in the industry. So with that, I always start each of these and plan to start each of these 12 episodes with this photo that you see here. And the premise of the entire webinar series is the book that I published last May on When Words Collide, Resolving Insurance Coverage and Claims Disputes. And most of the book is about resolving a claim that has been denied. That's the bulk of the book. And in fact, starting in May, the rest of the series will be devoted pretty much to that, resolving claims that have already occurred. But the first four episodes, we're spending time looking at ways to avoid the claim from ever being denied by making sure that you've identified the exposures, properly insured or risk managed them, and so forth. So that's what we're doing in the first four sessions. And today I'm going to talk specifically about prevention. One of my favorite quotations, and those of you who subscribe to my blog know that I'm a collector of quotations. In fact, I published a book a couple of years ago of quotations and essays, 52 of the greatest things anyone ever said and why. And one of my favorite ones in that collection is from General Jimmy Doolittle from World War II Air Force general. Said, one problem with Americans is that we're fixers rather than preventers. So much of my book and much of this series is going to be focused on fixing what has happened, but probably even more important, not as easy. It's not as easy to sometimes prevent things from happening, but it is just as important. In fact, it's probably far more important. I gave a couple of examples last week. I'll touch on those real quickly. And I wanted to recap a few of the important things I said last time and expand on a couple of things that we ran out of time last month. And then we'll dig into the prevention issues specifically that I want to talk about, and in fact, some specific policy forms. I gave a couple of examples real quick last time. One was a question that I got from a Minnesota agent who was insuring a waterfront property that had a bunch of portable docks. And in the wintertime, when the lake would freeze over, they would take all the portable docks in a warehouse and store them, then put them back in the spring. And the question was, under the ISO form that they insured all of their property under, it was the Building and Personal Property Coverage Form, ISO CP 0010. And there is a section of that form that says property not covered, which lists piers, wharves, pilings, and docks. So the insurance carrier's position was that those were docks and they weren't covered in any way by the policy. Well, the agent felt that listing, piers, wharves, pilings, and docks, referred to real property, not portable business property, that they're referring to fixed types of real property. And I think he's probably right. We're going to talk in a later episode about ambiguous policy provisions and using a couple of techniques to resolve those in the favor of the insured, one of those being a Latin phrase called nocere ausocis. And I'll just mention that, but we'll come back to it in depth next time or probably the time after that. But I think he's probably right. If you had a claim, I think you could argue that those are that the property not covered section doesn't apply to that. Well, why wait till you have a claim to resolve that? Because you know what the company's going to do if there is a claim for those portable docks. They're going to deny it. And you may win through arbitration, mediation, or just argument, or you may go to court and win. But why do that? the solution right up front is to use the ISO CP 1410 additional property coverage form. So if you work in commercial lines and you're not familiar with that form, make a note, CP 1410. You can take most of the property not covered and remove all doubt about whether something falls into one of those categories by using that form. Another example I gave was if an employee of a business rents a car, is that a symbol 8 or a symbol 9 exposure under the ISO business auto policy or other carriers using policies that follow ISO symboling system? The significance is you can cover physical damage to that rental car under symbol 8, but not under symbol 9 under ISO rules. Symbol 8 is designed for rental car exposures. Symbol 9 is designed for employees using a vehicle of their own or owned by somebody else. So the question when they rent a vehicle is who's renting it, the business or the employee, because that determines whether it's symbol 8 or 9. And the way that you get around that, the way you resolve that up front is to use an endorsement that ISO created called the CA 2054. It's employee hired auto. It establishes that is indeed a symbol 8 coverage, that you can cover the physical damage. And in fact, that coverage under the business auto policy is primary coverage, even over the employee's personal auto policy. So those are two opportunities for you to have a claim that could be denied. And we could argue using the techniques and the doctrines and the principles that I use in the book and that we'll talk about in upcoming webinars. But the idea is, why get to that point? Why not resolve it up front? Another way that you can have things like this occur is through what I call premium games. Sometimes you find an insured who wants to play games with premiums, or there are agents that do the same thing. You probably compete against them. And an example would be a business that had a fleet of private passenger autos, one of which could not pass the emissions test of the county where the business was located. So what they did after it had flunked a couple of times was they titled the vehicle to one of the corporate officers who lived in a neighboring county that did not have an emissions testing requirement. So the issue was, how do we ensure that? Now we've titled it to somebody else, not the business. Is there a way we can continue to cover that in our business auto policy? And it can be done in most states. It may involve leasing the vehicle back to the company. It's going to involve at least a couple of endorsements, but it's possible to do it. But the better resolution of that is, why not get rid of the vehicle or get it repaired so that it can pass the emissions test, rather than go through all this long, drawn-out process to insure it a different way. Another quick example was this was an Alabama business owner who bought a car for his daughter's college boyfriend to take and use during the summer while he was working in Atlanta. And he wanted to continue to cover that vehicle on his business auto policy, and even though it wasn't really used in his vehicle. So there are ways that you can do that, but the best way is to not do what this guy is doing. And sometimes I know as agents, those of you who are agents, encounter these messes from individuals who've done things, usually before they ever ask you about them, and you've got to solve their problems. Well, the important thing is to try to solve the problem up front, and that's where we're going to devote most of our time today. Last month, I introduced everyone to two concepts of two ways to deal with claims disputes. Again, the one that we're going to talk about from May on involves resolving and advocating on behalf of customers. What we've been talking about February, March, and today are ways to avoid or to prevent those. And again, I can't stress enough how important this is. It's just as important or more important than resolving a claim after it's been denied, by preventing the dispute from ever arising. So that's where we're going to focus our attention today. I'm going to give you a bunch of examples using ISO and non-ISO forms in both commercial and personal lines to make you aware, in particular, of some policy forms to be wary of that you sometimes find in the packages that you're writing for customers. None of these, or most of these, you don't ask for, but sometimes companies put things on policies that you didn't ask for. Then on the list that you see there, what we learned today, only the red thing is what we're going to talk about today. The others, the basics, the doctrines, the principles, the 4-step process, all of that's going to be coming up in the last 8 remaining webinars. So again, 2 ways to deal with them: avoidance, which we're going to discuss today, and resolution. There's a graphic. I talked about this last time. I found this on a legal site. It says disputes and lawsuits, how to deal with the inevitable. And I made the point then and today that these are not always inevitable. The disputes aren't inevitable, again, if you properly identify the exposures and insure or risk manage them. But things do happen. And again, that's what May through December we're going to address in those webinars, that sometimes claims do happen, they're denied, and rather than resolve them through a lawsuit, lawsuits are not inevitable. You can resolve them by working usually with the adjuster. Sometimes there are other tactics that you have to use by going to a supervisor, home office, insurance department, your trade association if you belong to one. Ultimately, you may get a lawyer involved, but there are lots of ways to resolve coverage denials favorably for insureds if you're convinced that they truly are covered or could be covered without going to trial or without getting a lawyer involved. And it's important, why do you want to avoid litigation? Well, obviously it's expensive. It's incredibly time consuming. If any of you as agents have ever been involved in an E&O claim, you know how emotionally stressful it is, how much time it takes, and the expense involved. But there are other reasons that you want to avoid litigating. And the carriers have their reasons, and you and the insureds have your reasons. One of the problems for carriers is if they litigate something and it gets to the appeals court level or above in state or federal courts, if the decision is made in the insured's favor, then you now have a precedent-setting court case that applies to all of the future claims of this type that the insurer may have. And in fact, they may have denied claims in the past that now the courts have said should have been covered. They may end up having to go back and look at those files and address those issues. On the other hand, if the decision is on behalf of the insurer that no, there's not coverage, that can create problems for consumers and for businesses. 2 of the biggest ones, and we don't have time to get into a lot of detail about these, or really any detail, but under the CGL policies, the ISO form, I wrote an article some time ago called the CGL No Occurrence Claim Denial. And it has to do with about 40-something% of states that have ruled that faulty workmanship is not an occurrence, and therefore coverage is not triggered under the CGL policy. And that's problematic because sometimes faulty workmanship arises from a subcontractor's work. Later on in the policy, there's an exclusion for faulty workmanship, but it makes an exceptions for subs work. And the problem is you never get to that exception if you never trigger the coverage to begin with, because it's not an occurrence, as some of the courts have said. So that's a very unfavorable ruling for businesses in those states. In personal lines, it involves something I call the where you reside issue. And that's that there not many states have considered this issue, but the ones that have, it's split about 50-50 on whether there's coverage or not. And it has to do with somebody that has a homeowner's policy and then they discontinue their residency in the home. Maybe they get transferred to another state. They have to move immediately. They put their home up for sale. They leave their homeowner's policy in place. Maybe they're getting another home, and in the meantime, they move before they sell, or as an alternative to selling, they rent their home out to somebody, but don't realize that they only have a homeowner's policy. There's some courts that ruled that once your residency ends, then your coverage on the dwelling ends. So you could have the dwelling destroyed by a tornado, find out you have no coverage in those states. And it's because of the case law that are in those states. I have a friend who is a risk management consultant, and he is convinced that some insurers will try to move every a litigated claim they can to federal court. The reason being, according to him, is that federal courts are much more favorable in their decisions to insurance companies. And I just saw a report recently. It's from Alexis. I think it was October or so of last year, called their insurance litigation report. And they found that where the question is whether the insurer has a duty to defend a liability claim, when it goes to federal court, 80% of the time they agree with the insurer that there is no duty to defend. If it's a question of indemnity, where it's a coverage issue, is it covered or not, that insurers win about 85% of the time in federal court. It found out on the issue I just mentioned of whether something is an occurrence in general or not just CGL, but any liability policy, that the courts about 2/3 of the time find that something that happens is not an occurrence that triggers coverage under the policy. Federal courts, according to this report, are generally more favorable to insurance companies on bad faith types of claims, even though that varies by states. There are lots of states where bad faith claims are rare, at least successful bad faith claims. I know an attorney in New York who said, I think it's been over 20 years since a New York appeals court has found that an insurance company is responsible for bad faith. So recapping what we looked at last week, when we talked about avoiding or preventing claim disputes, I gave 7 types of issues that are involved in that. And an important one I want to mention again is the foundational principle that the purpose of insurance is to insure. When you're dealing with claims people, hopefully they're looking for coverage and not a way out of coverage. I think most of them do. They want to be fair and do the right thing. And the other thing is to never forget the mission of the industry. And I'm going to come back to that, as I will do on each one of these webinars, and talk about what really is the mission of the insurance industry. Another thing that we talked about last time, and there were a couple of items that I wanted to address because we ran out of time, is 3 sources of coverage gaps that cause disputes. And I've kind of referred to this earlier in this webinar. Number 1 is the failure to identify exposures or to quantify them. Like, what's the square footage of a home? What are the proper limits? What are the values in question? Anyone who subscribes to my blog knows that I sometimes give insurtechs a hard time. And an example I give often, just wrote about it recently, is Hippo is one of the insurtechs that writes homeowners insurance. And I got a Hippo quote on my home to see what it was like, because they say that they can insure you on a homeowner's policy, and I think it's 60 seconds. So I went online. It wasn't anywhere near 60 seconds, but one of the interesting things that I found was when I did get a quote, they had the square footage of my home understated by 1,200 square feet. And they were getting that square footage information from a real estate kind of website, like Zillow or Trulia or one of those. And they are getting their information largely from county tax records, which are way off in many cases. The home that I'm in has been remodeled a couple of times at least and expanded the living space. So the square footage was way off. It resulted in a coverage A value of my home at least $200,000 less than what it should have been. And the implications for a consumer who's not using an agent and going directly on one of those websites is pretty obvious. I just did it again recently. I went back. It's been a year or two since I did it. This time they had my square footage 1,600 square feet more than what it actually is. So it was a 2,800 square foot swing. I have no idea where the information came from that says my home is way, way, way bigger than it actually is. So it's important that you identify the exposures and use accurate information. I usually suggest to people that they not rely on the big data. Reaching consumers with that message is more difficult than reaching insurance professionals. The second one is the failure to insure or risk manage known exposures. I had a situation come up recently where there was a condo insured getting a condo policy. They were looking at a quote on a named perils basis. The agent could give them open perils coverage, what we sometimes shouldn't but do refer to as all risk coverage, for an extra $16, and the insured refused to pay another $16 to get open perils coverage. If I'm the agent, personally, I would just quote everything open perils. If that's the difference I'm looking at, I would never even offer name perils, because you're basically opening yourself up to a potential E&O claim by doing that. You can sometimes situations can create exposures that weren't there before. You've seen that probably if you're dealing with somebody who has a trust. A lawyer creates a trust. The lawyer knows nothing about insurance, doesn't realize that they've created an insurance situation where now the property, a home or vehicle or whatever, is owned by a trust and not by the person who's the named insured under a policy. I've seen, and I'll probably try to talk about this in a later webinar. One of the worst things I've seen, and I've seen it several times, is where an attorney or sometimes even somebody who manages personal finance, an advisor, will recommend that a family put a teenager on their own auto policy, usually at minimum limits. And in one of our subsequent webinars, I'll give you a real life example, in fact, several of them, of where that can backfire and financially ruin and destroy families because of that incredibly bad advice. I had another situation that came up not long ago of creating an exposure that didn't exist. It was an insured in a homeowner's policy had bought an ATV for a 4-year-old. If you could imagine that, he said it was a low speed ATV. It would only go 30 miles an hour. But could you imagine a 4-year-old hitting a tree at 30 miles an hour on an ATV? One of the obvious ways to avoid the potential for a claim and possibly a claim denial is to avoid it. Don't buy 4-year-olds ATVs. Don't put teenagers on their own auto policies. Or if you do, there's a way to do it the right way and not the way that it's usually done. So sometimes we can create exposures that never existed before by making bad decisions. And the third item there that I wanted to mention, which brings us to much of what we're going to talk about today, is the failure to quality control policy deliverables and risk information that we get to make sure the information, again, going back to the number one, identify or quantify exposures, is accurate, and make sure that we know what's being in the policy forms that are being delivered. There's an old saying about be careful what you ask for. And to illustrate this point, I changed that to be careful what you don't ask for. Because when you make an application with the carrier to insure somebody, usually on a package, there are certain forms, certain coverages that you ask for based on your working with the insured to identify their known exposures. So you ask for certain policy forms or certain coverages, maybe that carrier has that others and ISO or other companies don't have. And you want to quality control what comes back, first of all, to make sure what you asked for is actually there, that they didn't replace what you asked for with something that's wrong or a little bit different or the best they can do or what they think is equivalent or whatever. But the important thing is you want to check those policy deliverables for what forms the company has included that you did not ask for. And that's where the problem sometimes arises, particularly in the surplus lines marketplace. Not to give E&S markets a hard time, but they often use ISO forms, or they'll use proprietary forms, but usually they use ISO forms, and then they add all kinds of proprietary endorsements that carrier has come up with, or they're using certain ISO forms that be better for the insured that they didn't use. And I've got one more slide to address, and then we're going to get into specifically that issue, specific policy forms. This slide, I just wanted to point out that we're talking about insurance, but don't forget the risk management aspects. Insurance is just one form of risk management. And if you are qualified to do so, you can assist an insured not only in insuring their exposures, but giving them advice about risk management. This is something you can learn. There are designations in the industry. The institutes out of Pennsylvania have the associate in risk management designation. Those are the folks that do CPCU and a bunch of others, but they have an associate in risk management. It was the second designation I ever got in, I think, 1982. The CIC folks have their certified risk manager designation. And that's another possibility. In fact, you could do them both. I would highly recommend either one of them. And then there are all sorts of reference materials that you can get. Probably the best being, other than belonging to RIMS or a society like that, as far as reference resources would be IRMI, the International Risk Management Institute, where you can learn more about the risk management process. But there are the various, won't dig into these in detail, but there are the various approaches to risk management other than insurance. Years ago, in the first home my wife and I lived in, we discovered during a termite inspection that we had this brown fungus in a crawl space of our home under the floor supports, the concrete block walls, etc. And there was no coverage under a policy at the time. Sometimes today you'll find limited coverage for funguses, mold, etc., but usually it's only as a result of a plumbing leak. What we had was a humidity problem in that crawl space. So there was no way to really insure the exposure. So what we could do from an avoidance standpoint, I guess we could move retention. We could knowingly not do anything, but we chose to take loss control measures. First one being loss reduction. What we did was we had a firm come in and spray a borate solution that killed the fungus. It cost $300 to do that. Only had to do it one time. It also provided insect and termite protection to the wood joists that were sprayed. Then the other thing is loss prevention. In addition to that, we installed a humidity controlled exhaust fan. And what it did was when the humidity level got to a certain point, it began to exhaust out a vent under the house and create a breeze that cleared out the humidity under the crawl space. So those are things as an agent or a broker or a consultant that you can do that go beyond insurance. Again, if you are capable of doing that, and as a caution, you want to make sure that your E&O policy protects you, because some E&O policies only cover what an agent normally provides in the form of services. They may or may not cover a risk management type approach. So you want to make sure that you have coverage in place. A great loss prevention measure is if anybody has one of these Ring doorbells. I installed one last year. You can see people coming in. Sometimes you may have people that are casing the joint. They come up, they see that they have just been videoed, and bam, they are gone. They know there's now a record of them, or at least they think there's a record visually of them, so they forget about ever hitting that place. The next slide, now we're going to get into some forms, and in that half hour that remains, I'm going to talk about coverage forms and give you specific practical examples that you can put to use this afternoon. And I'm going to talk, I'll try to split it fairly evenly between commercial and personal lines. I actually do a couple of other webinars called Finding and Fixing Coverage Gaps. One is Finding and Fixing Commercial Lines Coverage Gaps, Finding and Fixing Personal Lines Coverage Gaps. And I've borrowed some of the examples I use in those programs to illustrate the points I want to make about how you can choose the right form or identify bad forms that can be removed or perhaps negotiated to avoid a claim from being denied by having the coverage in place. The first thing you need to know, though, is how do you tell the difference between an ISO form and a proprietary insurance company form? And it's important because most of the continuing education that we do that's offered or that we partake of involves ISO forms. If it's inland marine, it's probably AAIS forms, but they're industry standard forms. And the reason is it's impossible to do a commercial property seminar and look at every insurance form that's in existence. IRMI does about as good a job as anybody that I know of in the area of commercial umbrellas. They actually have a reference book that has just about every commercial umbrella that's in the marketplace. I have no idea how they keep these things up to date, but you can actually compare umbrellas among carriers. But it's not something you normally do. It's not something that on a regular educational basis that you do. You mainly go to programs that talk about ISO forms. So it's important to know, if you've taken some notes, about whether the form you're looking at is ISO. And if it is, you probably or may know the form pretty well, or if it's a company form that you don't know unless you read it and study it. So how do you tell the difference? And this became an issue for me when I worked at the Big I. I was with the National for 17 years, and I built and built up their virtual university. It had and still does have an Ask an Expert service populated by, I think, 40 something of the best insurance people in the country. And we would get coverage questions. The submission form would say that if it's an ISO form, we need the full form number. And we had access to ISO forms, but if it's not an ISO form, if it's a company form, we need to know what company form it is by the agent asking the question, providing an actual copy of the form itself. So we had a means where they could attach usually a PDF copy of the form, and to the best of our ability and time, we would take a look at proprietary forms. So what we found out over time was somebody would submit something or submit a question and say, this is ISO form so-and-so. We'd look at the form number and know immediately it's not ISO. And clearly they did not understand that they were dealing with a form that could be dramatically different from an ISO homeowners or CGL or crime or whatever form. So it's important to understand whether it's ISO or not. And there are three basic tests that you can use to determine that. The first one is the structure of the form number. If it is an ISO coverage form, it almost always will have the same structure, which is 2 letters, 2 numbers, 2 numbers, 2 numbers, 2 numbers. So it's 8 numbers in 4 groups of 2, and starting off with 2 letters. The 2 letters tell you what line of insurance it is. If it's homeowners, the form number always starts with HO. If it's a private passenger auto ISO form, the form number will be PP. If it's CGL, it will start out CG. If it's commercial property, it'll start out CP, so on. So if you see one that starts out with different letters or starts out with numbers or anything else, then it's not ISO. The second test is the addition date. In my book, I take all of ISO's major lines of insurance and I go back about over 30 years and list every countrywide addition date of their BOP program, their commercial property, commercial auto, crime, homeowners, etc. For CGL, I actually go back prior to 1985 to forms from 1941, which is generally considered to be the first standardized general liability policy. It was issued by the old casualty rating bureaus in 1941, updated in 43 and 47 and 55 and 66. In 73, ISO came around in 1971, so it became an ISO form in 1973, and then had major revisions beginning in 1985. But if somebody says, I've got an ISO homeowners policy, it's the HO00 03 05 83. 0583 would imply that it's May 1983. Well, I know for a fact that ISO had no 1983 countrywide homeowners program. It's possible that they introduced a program in that state on a state-specific basis, but it's unlikely. Usually, if you don't have a homeowners form that is either dated 82, 84, 91, 2000, or 2011, it's not ISO. And the third thing, and maybe the best test, is the copyright notice. Every ISO policy, at least going back 30 plus years, at the very bottom of the page, and usually on every page, it will say copyright and a year by Insurance Services Office Incorporated, or copyright and the year by ISO Properties Incorporated. It'll say Copyright Insurance Services Office or Copyright ISO Properties Incorporated. If the copyright notice starts out with the word includes, it says includes material copyright, whatever date, by ISO Properties, etc. That tells you that it is not ISO. The includes word means that this has ISO form language in it, and we have to say that because we're licensing their forms, and that's a requirement in the licensing agreement. But it may be mainly ISO, or it may be very little ISO. It may be 90% a company form, but they use enough ISO language or enough of the formatting of an ISO form that they have to include that copyright notice. So anytime you see the word includes in the copyright notice, that tells you immediately that it's not ISO. And I got this slide from one of the other programs I do, and I gave a bunch of examples over 15 or 20 minutes of where you will find these differences. That's what it talks about, test results. We don't have time in just an hour program to look at all of those, but the tests that I just gave you work probably 99% of the time. There are examples. Sometimes I've seen company forms that are additional insured forms. ISO one that a lot of people have always asked for in the past is the CG 2010-1185, the 1985 edition of that ISO additional insured endorsement. And there are reasons why they want that particular endorsement, but most carriers don't provide it. Hardly any carriers provide it. But I've seen a few that say, here's the CG 201185, and when I look at it, it's the original ISO form plus the modifications that this company has added to the original ISO form. And at the bottom of the page, if they've done this, they need to say includes copyright information. But what I found on several occasions is it doesn't say includes. It just has the old 1985 ISO copyright notice. And so those things do happen. When I come across them, I report them to ISO because they need to get that fixed so people aren't confused. But generally, the test that I just gave you will work. Okay, the last part of the program, I'm going to give you a bunch of examples. If you elected to download the handout for the program today, you can print it out, and some of these will just be a reference. We're coming up on some of the slides, I've got lists of ISO endorsements that you can keep handy. And but all I can do on this is just give you some examples from some of the lists I've found. What I've done with the commercial lines endorsements is I've split them into 4 categories. Endorsements that, as I mentioned earlier, in quality controlling policy deliverables, sometimes company attach endorsements that you didn't ask for. And these are just some examples on an upcoming slide of things to be wary of, in particular, some of the worst ones I've seen. The second category is endorsements that you might want to attach on just about every policy and why they're so important to include them. As I mentioned earlier, we looked at one that I would just include automatically, or like using open perils coverage in a condo form, just quote it on everything, because if it's only $16 or $50 or whatever, it's worth quoting. The third category is exclusions or limitations, coverage limitations that you can often get corrected by just asking. Sometimes you can ask a company to remove an endorsement and they'll do it. Depends, sadly, depending on where your agency falls, on who the agency is. Some agencies can get things done from certain carriers that other agencies can't get done because they have clout or they have a reputation with that carrier. So sometimes you can get bad endorsements removed. Sometimes you can get them replaced by lesser endorsements or less onerous endorsements. Sometimes this is done free. Sometimes there may be an additional premium. But the important thing is to know that you have a problem endorsement and make an attempt to get rid of it. If you can't get rid of it, then you need to let the insured know that this could be very bad. One we'll look at later on is classification endorsements. And the fourth category are endorsements that are often misunderstood. I just give a few random examples. They're probably a lot of endorsements that don't do what some people think they do, but I'll give you some that I find all the time are misunderstood. Then the last thing, whatever time's remaining, I'll give you a list of personal lines coverage considerations. And you will have my email address. It's on the handout. I think it's on the last slide of this presentation. If when you take a look at the handout later on or look at the recording of this webinar, if you have questions, shoot me an email. I'm always happy to answer questions about any of the webinars I do next week, next month, next year. Can't do it posthumously, so I'll be 69 next month. I don't know how much time I've left, so if you have questions, get them to me quickly. Okay, forms you didn't ask for. These are different categories, and these are examples of what I find often in the surplus lines marketplace. Again, you see a list there of different categories. We just don't have the time to look at all of them, but illusory coverage. Sometimes companies giveth and companies take us away. I think in a later webinar, I'm going to talk about my personal experience when a tornado hit my home, and I had to deal with the tree service companies. I had 19 trees down in my yard. I mean, big trees, 40 to 80 foot trees down in my yard, and had to get a tree service company. And of course, I wanted proof of insurance. I had one of the bidding companies show me their portfolio of forms, their deck page, their certificate of insurance, etc. They had an ISO CGL policy, which is great. Nothing wrong with ISO forms. Problem was they had 42 endorsements attached to that CGL policy, and many of them were not good. One in particular only covered them for how they were coded and rated. And they were coded and rated as tree trimming and pruning, not taking down 80-foot cedar trees. The other endorsement was the bad one, though. It excluded ongoing operations and your work, which is another way of saying completed operations. So the bottom line was, because of that endorsement, they had no coverage for anything that they were doing, and they were completely oblivious to that fact. To me, I wouldn't call that illusory coverage, and in fact, it's sad to say that many courts don't think that's illusory at all. If a policy covers anything, they'll say it's not illusory. To me, it's not only illusory, to me, it's insurance fraud. When you sell somebody a policy, you know what they do for a living, and you know the policy you sell them does not cover what they're doing. To me, that's beyond illusory. But again, the sad thing is courts will uphold those kinds of policies. So it's up to you, the agent, to get that stuff fixed, or at least make the insured aware of limitations. Ambiguous policy provisions, we're probably going to spend an entire webinar or a big part of one of the webinars in the series talking about ambiguities, because that ambiguity is the mother of all claim denial controversies, that a policy provision is ambiguous. One that I gave, I think last time or the time before, was a homeowner's policy that excluded any farm-like structures. And the question is, what does farm-like mean? And it was a claim denial, involved a detached garage. Guy kept his car in it, stored a few things in it, but it was built to look like a little barn. It had a window up above that looked kind of like a hayloft, etc. The adjuster denied the claim, even though the policy covered other structures on the premises, because this was a farm-like structure. Trial lawyers, plaintiffs' attorneys, policyholder attorneys refer to these things as weasel words, meaning they think that or claim that insurance companies use very ambiguous, broad, vague language like that so that they can choose what they want to cover or not cover. And I don't believe that for a minute. I don't think companies do that. It's not to their advantage to have ambiguous policy provisions, because you don't know how to price the coverage if you don't know whether a court will uphold the language or not. I think policy provisions are ambiguous usually because policy language is very difficult to write clearly. When I retired from the Big I at the end of 2016, the first consulting job offer I had was from a new captive insurance company. They were looking for someone to write property policy forms from scratch. They didn't want to use ISO forms. And I asked them why, and they said, well, they're too expensive. Their licensing fee costs too much for our needs. And I told the guy, I said, well, you haven't seen my consulting quote. It's going to be a lot more than what ISO's fees possibly could be. Use ISO forms. That's that one thing ISO is good at, is writing policy forms. Unfortunately, manuscript endorsements and so forth are often poorly written. Classification code exclusions. I just had one come up I think it was last week. It involved a classification code for an HVAC, a heating, ventilating, and air conditioning contractor. And they were only covered for how they were classed and rated from the commercial lines manual. And sometimes businesses branch out into other things. Maybe they start doing some plumbing work or whatever, and they would have no coverage for that. These are not good endorsements. You want to always try to get class endorsements removed from a policy if at all possible. Another one is if you insure any general contractors or any contractor that uses a lot of subs. Special condition, contractor warranty, they're known by different names, are endorsements that some companies will attach because they want the general contractor to make sure that all of their contractors and subcontractors have insurance coverage, workers' comp, CGL, etc. So what they'll have sometimes as an attachment to their GL policies is if there's a claim where the contract requires you to be named as an additional insured under a subs policy and you're not, or their policy doesn't cover the claim for whatever reason, then our policy is going to have problems for you. Either we're not going to cover the claim, or you're going to have a deductible, or you're going to have a sub limit, and the requirements, the limitations go on and on and on. But anytime you are tying coverage under your insured's policy to coverage or lack thereof under another policy, you don't want that endorsement. Be wary of additional insured endorsements if you work in commercial lines. ISO has 30-something. IRMI, the International Risk Management Institute, has a collection of over 300 non-ISO additional insured endorsements. Many of them are grossly inferior to the ISO form. Some of them are better, but many of them are not. Some of them don't cover on a primary and non-contributory basis. ISO does that with a separate endorsements that's used with their additional insured endorsements. Many carriers include the primary and non-contributory language in their additional insured endorsements, but some of these companies not only don't provide primary and non-contributory coverage, their endorsements are expressly excess coverage. Some of them are vicarious liability only. They don't cover any direct liability of the additional insured against something that you don't want, and probably put your insured in a breach of contract if they're at a work site. Prior work exclusions is another. Normally a general liability policy, for example, the policy that responds to a claim is the one that was in effect when the occurrence happened that generated bodily injury or property damage. Sometimes the actual work, the negligent work, was performed years earlier, but the policy that responds is the one that was in force at the time of the actual injury or damage. Prior work exclusions will remove that coverage by saying that if the work was performed prior to a date and that resulted in the current BI or PD claim, there's no coverage. So those are just some examples of particularly in the surplus lines market, there's some things to look out for. Things you almost always want. I mentioned this one earlier, the CA 2054, where an employee is renting an auto. If I still had an agent license, I would be putting this on every business auto policy that I write, the CA 2054. I don't think under ISO rules it's even premium bearing. You may have companies that charge for it, but I would put it on every one so I clarify that symbol 8 versus 9 issue up front. And personal lines, an endorsement that's often overlooked is PP 0306, extended non-owned coverage for named individual. Sometimes called the company car coverage. It's for people that have regular access to a vehicle, and their policy has an exclusion for that. Vehicles that are furnished or available for your regular use. I would look at this for any of your insureds that have access to a company car. Hopefully the company car is covered by a commercial auto policy, but you don't know that for sure. You don't know what the limits are. And also, in general, personal auto policies are broader coverage than commercial auto policies. So your personal policy may cover something excluded by the commercial policy. When I had a company car available to me, the cost for this endorsement was $20. And I don't know what it is today, but I've been told that it's still very inexpensive. Buy medical payments. Medical payments is incredibly inexpensive. You can buy the maximum for under an auto policy, for example, for pennies. And you may never need it, but it's so inexpensive that it's worth quoting it. And the last thing I mentioned here is limits. Always make sure you offer high limits. Many agencies have minimum limits requirements. They won't write anything, liability or uninsured motorists, less than X amount. And this is a reason. These are statistics looking at about 25 years of E&O claims. And you can see from the standpoint of inadequate limits, you have far more claims under a personal auto policy than you do under a CGL policy. Why is that? The reason's pretty clear. Most CGL policies are written at least $1 million limit. Many personal auto policies are written at state minimum limits, which for most states is 25, 50, 10, or something in that range. So when you write lower limits, you are asking for more E&O claims because they're inadequate. The way you avoid that, the way you reduce that dramatically, is by writing everything at least a minimum limit higher than that and offering even higher limits. Here are some forms, specific ISO forms that I want to at least give you a list of, even though we can't go into detail on these. Anytime you see an ISO form, that general liability endorsement that starts out CG21, it is not good. So you want, particularly if you're quality controlling a policy deliverable, you want to look for anything that starts with the CG21. The first three that I mentioned here, the 2139, 2426, 2294, if you ever see those on a policy, and you will see them most often on a contractor's policy, do everything you can to get them removed. These are horrible endorsements. In the surplus lines marketplace, it may be impossible if that's your only market, but with admitted carriers, this may be negotiable, or may even warrant moving the account to a different carrier if you see these three endorsements. These two here just gut contractual liability coverage in a CGL policy. This one guts faulty workmanship that involves a subcontractor. These are all bad ones. Another one is the total pollution exclusion endorsement. I had another consulting opportunity that came up a few months ago, was from an account where this endorsement, the CG2149, was added. ISO has two options for this. They have a total pollution exclusion. I think it's the 2155 with a hostile fire exception. Then they have an endorsement, I think it's the 2165, that's the total pollution with a hostile fire exception and a building heating, cooling, and dehumidifying equipment exception. There are lots of asphyxiation claims that involve HVAC equipment. There are contractors that do this kind of work. So either hotels, apartment buildings, HVAC contractors exception, you want to get rid of the 2165. And if you have to have a total pollution exclusion, at least try to negotiate the 2165, or again, move the account if you need to. Misunderstood forms. I'll mention the first two in particular. If you insure any lawn care services or pesticide or herbicide applicators, for years I heard from a lot of agents who thought that these bought back the coverage. Here's a claim that often happens. Somebody mixes a weed killer in a spray device that should have fertilizer in it. They spray it on the lawn and it kills the lawn. This endorsement gets rid of the pollution exclusion for that claim. However, it doesn't get rid of any other exclusions. And there are some property damage exclusions, particularly J5 and J6 in the ISO CGL policy, damage to property on which you're performing operations. So while this gets rid of the pollution exclusion, the claim still isn't covered. Now, if that spray drifted over to the yard next door, this endorsement could come in handy because the company couldn't cite the pollution exclusion, and they couldn't cite the damage to property on which you're performing operations because they're not working on the yard next door. So it does have some value, but it has no value for the endorsement that you have, rather for the account that it's being attached to. One other one, the CA 2048. Sometimes other parties want to be an additional insured on the business auto policy. I've seen them even ask for the CA 2048, which is called designated insured endorsement. And what this endorsement does to the policy is absolutely nothing. It does nothing to the policy other than say, if you are an insured under this policy and somebody's vicarious liability is where usually they're an insured, then this is a piece of paper that confirms that you are in fact an insured under that policy. But it doesn't make them an insured if they're not already an insured under that policy. And that's why you actually need a true additional insured endorsement. ISO added one not long ago, and they've had them, of course, on CGL for a long time. Okay, the last thing, we've got about 5 minutes left, so I'll run through some examples. Resident family member autos. I mentioned earlier that sometimes bad advice is given to your customers or prospects that they should put a teenager on their own policy because they don't have any assets, they don't have any income that could be attached in a lawsuit, get them for minimum limits. Just because they don't have any assets or income today doesn't mean that they won't tomorrow. It doesn't mean that 10 years from now they won't be living on their own, earning an income. I've had this arise in claims involving kids that went to medical school, kids that had an inheritance when they turned, say, 25 and inherited $3 million. Just because you don't have any money today doesn't mean you get out of a lawsuit or a judgment. And particularly in federal court, I know judgments, you can have garnishings and judgments that will last for 10 years with an option to increase that to 20 years. So they could be held responsible in the future. And in addition to that, if liability can be attached to the family, to the parents, by putting them on their own policy, you may be removing coverage under the parent's own policy for their own liability. And I wish we had time to talk about that issue. Feel free to email me and I will send you links to some articles that I've written about that if you're not sure what I'm talking about, but I've just scared you to death. So shoot me an email and I'll let you learn more about that. Rental car loss damage waiver, always recommend that they buy the loss damage waiver. It's what risk managers refer to as a belt and suspenders approach. I always buy the loss damage waiver. If the rental car is damaged, that usually takes care of it. But it doesn't cover everything. There are exclusions in the rental agreement, or I may violate the rental agreement. That's why I have auto coverage to fall back. But neither one is adequate on their own. There are limitations in auto policies. For example, diminished value claims. I've seen diminished value claims. Just saw one last week for over $9,000, not covered by insurance, but would have been covered by a loss damage waiver. It's common to see them in the $1,500 to $5,000 range. So you always recommend the loss damage waiver. I'll send you a link to some articles about that too if you want to learn more about it. Students at college, should they have their own renters policies? I can send you a link to an article about that. When my son was in college, I extended our own homeowners coverage. Even while he was in a dorm for 3 years and then he moved to an apartment, I still covered him under my insurance program, under my homeowners policy, under my auto policy, showing that his vehicle was garaged somewhere else, and under the umbrella. The reason is for him to buy all of those coverages on his own would have been extremely expensive. I've already got them in place, but there are some caveats to that too. If he dropped out of college and didn't tell me, he would lose his insurance protection, at least under the ISO homeowners forms. And the list goes on. Water leaks, some companies exclude any kind of damage from a water leak that takes place over weeks, months, or years. I could show you a half a dozen different phrasings of that. One of the things about the ISO homeowners policies is they don't exclude that. The ISO forms, if you have damage to your home that's hidden, it's under the floor, it's in a wall, it's in the attic, or you can't see it. Once you discover it and report it, it's covered. But that's only the ISO forms. Most of the company forms I've seen don't provide that broad coverage. And you can see there, the list goes on and on and on of opportunities to insure certain kinds of exposures. The last thing I'll wrap up with is the last few slides. I always show these at the end of every one of the webinars in this series. That's a professional oath. I hope everyone considers themselves an insurance professional. We work in a fantastic industry. I can't think of any industry more important to humanity, to businesses, an industry more noble than the industry that we work in. Never apologize. If you're at a party and somebody asks what you do, don't look down or apologize for being in the insurance industry. It's something to be proud of, the way we normally all conduct ourselves. Here's another picture of what this program is all about, what our industry is all about. It's all about who we are, what we do, and why we do it. It's to help people like this. And back to our original photo, this picture kind of visualizes what it's all about. This is what I call the mission of the industry. Never, ever forget in everything that we do professionally that the purpose of insurance is to ensure that the mission of our industry and every professional in it is to assist individuals, families, and organizations in minimizing their exposure to serious or catastrophic financial loss. Sorry, Hippo, sorry, Lemonade. InsureTechs cannot do this in 60 to 90 seconds. It takes an insurance professional like the folks on this webinar to be able to do these things. There's a plug for my book. There's the website, or you can order it on Amazon if you don't have a copy of it. And finally, there's my contact information. There's my website where I blog regularly. And there is my email address. Anything I've talked about today, feel free to shoot me an email this afternoon, next week, or whenever, and I'll be glad to follow up on everything that I talked about. And with that, Patrick, I am done.
Thanks, Bill, and thanks everybody for your time today. Looks like we're just a little bit after the bottom of the hour. So if you've got any questions, go ahead and send them in. You could send them. You have Bill's email, you have our email. You can just send them in and we'll forward them on. We had a few questions, all that got cleared up. And a reminder, if you lost audio at any point during the presentation today, the recording will be available soon, so you'll be able to catch up on the pieces that you missed, and we apologize for those folks that did lose audio. And don't forget to join us again next month, where Bill's going to start talking about advocacy, I believe is the title. Is that right, Bill?
That's true. We're going to start talking about how you get those denied claims paid all the time.
All right. Well, again, thanks, everybody. Thanks, Bill. And we'll see you next time with the next Academy of Insurance webinar. Have a great day, everybody.